We need to object. He can't show that photo.
We discussed this. The evidence is admissible.
The security camera was already recording when she pulled up to the gate. She had been there before, more than once, and every single time she had walked away angrier than when she arrived. But this visit was different from all the others, because this time she came prepared. This time she brought a key. Not her key, not a key she had any legal right to possess. A copy of his padlock key, made without his knowledge, used without his permission, on property that a court of law was actively deciding whether she had any right to access at all. She unlocked the gate. She swung it wide open. She climbed back into her large bronze SUV and drove forward, straight past two bright yellow warning signs mounted directly on that gate, signs that could not have been any clearer or more visible. And then her front tires found exactly what those signs had been warning about for weeks. The vehicle lurched hard to the right. Both front tires gave out. The SUV slid sideways into the drainage ditch alongside the path and came to rest at a helpless angle. Miles away, a phone buzzed with a motion alert. He opened the app, watched the live footage, and allowed himself a quiet, satisfied smile. 3 years before that moment, Marcus had done something that most working people spend their entire lives dreaming about. He bought real land. Not a narrow subdivision lot surrounded by identical houses and a neighbor who complains about your grass height. Not a place where someone else's rule book governs the color of your front door. Real, open, rural land, a rectangular property sitting on the eastern edge of a newer residential development of about 120 homes. That neighborhood had its own entrance, its own management company, and its own long list of rules. None of those rules had anything to do with Marcus, because his land was completely separate. He demolished the old hunting cabin that came with the property and built a proper home. He and his wife moved in and finally had the kind of quiet, open space they had always worked toward. The land felt like freedom. The views were wide. Life, for the first time in a long while, felt exactly right. Running along the southern edge of his property was a 15-foot-wide gravel path. It stretched from the HOA neighborhood's eastern boundary all the way to a rural road on the opposite side of his land. Marcus barely gave it a second thought when he first moved in. More than 100 families next door, however, had been thinking about that path every single morning for nearly a decade. It shaved 5 to 6 minutes off their daily commute, and not one of them had ever been told it wasn't theirs to use. The morning Marcus watched 4 separate cars roll through his private property in under 10 minutes. Casual, unhurried, completely at ease was the morning his quiet rural life developed its first serious crack. These drivers were not lost. They were not taking a wrong turn. They were commuting through his land, on a gravel path that appeared on his deed, his survey, and his property tax records as privately owned land, and they were doing it with the total confidence of people who had never once been challenged. Marcus reached out to the HOA management company. The woman he spoke to was courteous, but ultimately useless. She explained that since his property was outside the HOA's jurisdiction, there was nothing they could do. Her suggestion was that he put up signs. He did. Then he strung a chain across the path entrance. Within 24 hours, the chain had been unhooked and left on the ground. He replaced it. Someone unhooked it again. This happened 4 times in the same week. On the 5th attempt, whoever came through the path did not bother unhooking anything. They cut straight through the chain with bolt cutters and left it lying in the gravel. That was the moment Marcus understood he was not dealing with careless neighbors. He was dealing with people who believed the rules simply did not apply to them. A heavy steel gate went up, bolted to 2 concrete posts on the HOA side of the path, padlocked, immovable. A matching gate went up on the rural road side. Both ends were sealed. The silence lasted exactly 4 days before an unsigned note appeared tucked into his front door. It demanded the immediate removal of the gates. It cited over 100 affected families. It was signed only as HOA board member. No name, no contact information, as though the title alone was meant to carry the weight of a legal order. The following Saturday, a woman with golden blonde hair arrived at his gate in a large bronze SUV and sat leaning on the horn until Marcus came down to meet her. She climbed out in a glowing dark pink magenta jacket with an HOA badge clearly visible on the lapel, and she told Marcus with absolute certainty that he was blocking a community access road and needed to open the gate immediately. Marcus told her it was private property. She told him she was calling the police. A sheriff's deputy arrived, reviewed Marcus's deed and property survey on the spot, and told her directly and calmly that private property was private property and that she had no claim to it. She drove away, promising legal consequences. Within the following 2 weeks, 2 more padlocks were cut, 2 more police reports were filed, 6 security cameras went up, motion activated, cloud backed, recording every angle of both gates around the clock. The footage those cameras were about to collect would eventually be played in open court. After the 3rd padlock was destroyed, Marcus sat down with a property attorney and laid out every incident in precise detail. The chain cuttings, the repeated trespassing, the unsigned threats, the camera footage, every police report. His lawyer gave him a clear and actionable answer. In their state, tire deflation devices were a completely legal method of protecting private property from trespassers, provided that clearly visible warning signs were posted. He compared it to barbed wire fencing on ranch land, a widely accepted and legally recognized property protection measure with decades of precedent behind it. 2 commercial spike strip sets went in, one just inside each gate, positioned 10 feet past the entrance on the property side. These were not the aggressive law enforcement variety used in high-speed pursuits. They were the directional commercial type, the same kind installed at parking garage exits. Drive out through them the right direction, and the teeth fold completely flat. Drive in from outside without permission, and the teeth do their job. Both gates received large, bright yellow warning signs with bold black text that any approaching driver could read from a significant distance. Then the HOA served legal papers. They were pursuing a prescriptive easement claim, arguing the path had functionally become a community road through years of continuous use. They also argued the spike strips were a dangerous public hazard. Marcus forwarded everything to his lawyer. Neither of them could have predicted that the HOA's own representative would personally deliver the most powerful piece of evidence the case would ever see, and would do it entirely without being asked. Marcus was out of town on a work trip when the motion alert came through on his phone. He opened the camera app and watched the live feed from the HOA side gate. The golden-haired board member was there, alone this time, no backup, no bolt cutters. She reached into her bag and produced a key that opened his padlock, a copied key, obtained without his knowledge, used to access property she was simultaneously suing him in court to reach legally. She unlocked the gate. She got back behind the wheel of her large bronze SUV. She drove forward, past both warning signs mounted directly on the gate she had just unlocked, signs that used the words "tire deflation devices" in large capital letters, and continued onto the gravel path. Her front tires reached the spike strips. The SUV dipped forward. She overcorrected. The vehicle veered sharply to the right, left the gravel surface, and came to rest at a slanted angle in the drainage ditch running alongside the path. Both front tires deflated. She got out, stood beside the tilted vehicle in visible distress, and made a phone call. A tow truck came 30 minutes later. Nobody closed the gate when they left. Marcus called his attorney the moment the clip finished playing. Weeks later, in a wood-paneled courtroom, a judge watched that same footage without a word. Then he denied the prescriptive easement claim in its entirety. He ruled the spike strips a lawful property protection measure, given the extensively documented pattern of trespassing and property damage. He noted, in direct language, that the HOA's own board member had appeared repeatedly throughout the evidence record, and suggested that the organization consider itself fortunate that a countersuit had not yet been filed. His lawyer leaned over quietly and reminded him that they had, in fact, already filed one. The countersuit settled at just over $15,000. The HOA's operating budget, drawn from the monthly dues of every single homeowner in that 120-home development, absorbed the majority of the total. The golden-haired board member paid approximately $3,800 directly out of her own pocket, covering the damages tied specifically to her individual actions: the cut locks, the bent gate hardware, the duplicated key, and the criminal trespassing citations she had collected over the course of the dispute. By a binding condition of the settlement, the HOA was required to send a formal written notice to every resident in the community. That notice stated plainly and without softening that the gravel path along the eastern property boundary was privately owned land, that legally installed property protection measures were actively in place, that any resident found using the path without permission would face HOA fines in addition to any criminal charges the property owner chose to pursue, and that the HOA would not provide legal representation or defense for any resident who chose to trespass. The board member stepped down from her position within a month of the settlement being finalized. At her last board meeting before resigning, she reportedly attempted to build opposition against Marcus one final time. She was met with near total silence. The neighbors who had watched their HOA dues disappear into a legal settlement she alone had provoked were not interested in another round. Marcus heard about that meeting from one of the few HOA residents he had developed a genuinely friendly relationship with. He said most people in the neighborhood were simply tired of the drama, tired of the cost, and quietly relieved it was over. Marcus and his wife still live on that land today. The gates are still there, the signs are still there, the cameras are still running, and the spike strips are exactly where he installed them. The gravel path that was never a public road, never a community easement, and never anyone else's property to use remains precisely what his deed stated on the day he purchased it. His land, his rules, his boundary. Some people learn where the line is by reading the signs. Others need to drive straight through them. Either way, the line does not move. Drop your HOA story in the comments below, because if this one taught us anything, it is that you are almost certainly not alone.